Welcome to Show Money, the only show exclusively dedicated to the business of mixed martial arts. I'm Paul Gift, the economist. With me, as always, we have Jason Cruz, our lawyer, John Nash, the man who knows everyone and everything in MMA. And we're recording today on Sunday, March 24th. And today is a special day for us because we were just looking it up. John was just looking it up before we came on air here. Our very first show, Show Money 1, was in February 2015, 3 months after the antitrust lawsuit was filed. And so we were talking a little bit about that, along with some other things, I think. But from the very beginning, we've been covering this thing from pillar to post. And I'm gonna pat us on the back a little bit. We are the three people who have been covering this thing the most. And outside of the attorneys and economists on the case, probably the most knowledgeable about it. And we're doing the wrap-up show today, giving you our take on sort of what we thought about every single thing and how it all ended. And Jason doesn't understand why I'm celebrating, but I'm celebrating with some Fortaleza. If you know about this, you know. If you don't, try to find out. But Jason, I'm going to toss it over to you. Uh, One, how surprised were you when the settlement actually happened? I believe, was it Wednesday? Yeah, it was Wednesday because I was giving final
13th,
exams
March 13th.
on Wednesday last week. And what was your kind of take on? I know we don't have full details on the settlement yet, but your take about if one party sort of beat the other or not.
So I think the SEC filing said they actually settled last week, the 13th of March. But anyway, we knew that they were going into private mediation, which I had thought would be a sign that the parties were serious about negotiating because you had to pay for it yourself. Little did I know when I talked to and I've done this before. I've done private mediations and they last a day, but these guys, whoever they got, talking to real lawyers, you pay $25,000 a day to go, and people will just walk out halfway through because fuck them. You know what I mean? That's that's the tenor of B. But in this case, uh, it seemed like the parties were willing because there was pretty much dead silence for about a week there, and you would think that you would hear something from someone if they settled or did not settle or say, that's the negotiations, we're done. But that didn't happen for at least from what I know. I don't follow anybody on social media, and the attorneys, let's be honest, shouldn't be on social media tweeting things, but we're in a new age now. But anyway, was I surprised? Kind of, just because I thought that my basis was that it would go to trial. They were not. No one was going to blink, and then from there it would settle before a verdict, before someone would tell them what to do. Because if the verdict would have come, there would have been an appeal or whatnot, and there'd be more money. What it came down to were a couple things for me. One, money on both sides. Both sides did not want to expend the money that it would take to cost for it to go forward to trial. If you think about it from the plaintiff's lawyer's side, we could talk about compensation for them in a minute, but they have carried probably, I don't know, I was thinking about this, maybe $5 million worth of just costs, maybe probably more. I don't know. I'm not a good estimator, but uh, um,
Plaintiff side you're talking about?
just plaintiff side, yeah, paying for experts, paying for just
Oh,
paying for parking,
the experts alone are probably 5 million minimum.
yeah,
That's insane. I didn't want to interrupt, but the
yeah.
probably 5 million a year they were spending.
Yeah,
So,
yeah,
so
Paul,
that's how
what the fuck are
insane
you
these things
doing?
are.
You should, that's what your next thing should be after this Zuffa, Lee versus Zuffa under your belt. I mean, my God, what are you doing just doing this thing, show money? Anyway, yeah, so yeah, the costs are just really, outstanding. And they weren't, if they lost, they weren't going to ask it back from ask it from the plaintiffs. So, I always think of the movie version of Civil Action where they're sitting in the dark and the electricity goes out because they spent all their John Travolta and his lawyers have spent all their money. That was not going to happen. That was not going to happen to the plaintiffs' attorneys. But it's still, from a business perspective, if they had lost, it would have been a huge gut punch, just because 10 years of basically, you could call it an investment in this particular case. And if they received nothing, that would be a tremendous failure, just a bad effort because of everything that we've seen through the 9 years. That would have been terrible. Now, from Zuffer's perspective, we just saw them pay out $20 million to Major League Wrestling last year, or yeah, at the beginning of the first quarter, maybe last year, something like that. They paid $20 million for a shit complaint from Major League Wrestling. $20 million. I don't know if that's a good benchmark, but it showed that TKO Group was willing to pay on behalf of WWE a certain amount to get rid of an antitrust lawsuit. Now, we won't get into that, but I'll just tell you, it was not that good. It was not that good of a lawsuit. The plaintiffs' attorneys in the UFC had a better lawsuit there. But they would still have to expend a lot of money. Also, obviously, the treble damages situation would be the greatest fear. Now, attorneys tend to think of the worst case scenario here. So I would think that there would be some attorneys on that side of the aisle for Zuffa that would be worried about how to explain to the powers that be at TKO or Dana White or whoever, how they would lose this case and get hit with that great of a jury verdict, because it would be bad. And then if you appeal, as we know, you have to post a bond, and so that wouldn't be good for Zuffa as well. Now,
that I think is a big deal, by the way. Yeah.
Yeah. Well, I mean, I heard it's easy to do. Just ask what's his name. Anyway,
Donald Trump.
Anyway, sorry to go long, but who won or lost? I'll give you the lawyer answer. It depends. The plaintiffs got money. They did get money, and some people will. I mean, we don't know how it'll be divvied out, but I think that the people who stayed in the organization long, had an X amount of fights, will receive a great amount of compensation. I don't know. Maybe one of you guys could help me out, but they'll probably get, maybe mid, low six figures. I don't know. But if you were to look at it from the perspective of, well, what changed? Are the contracts changed? Well, did a court of law say to them, you have to change your contracts? No. So the TKO Group paid them off. They get money, and we continue business as usual. So from that perspective, that's not good. From Zuper's perspective, from TKO Group's perspective, it's a blip. Look at what happened with their stock prices afterward, right? They announced that the case had settled, and pending court approval, but the stock made a surge back up. So things are good. Things are good, still good with the UFC. I don't particularly know now how to affect change for fighters legally from a litigious perspective. Maybe through legislation would be the next, or another shot at legislation, perhaps. But this was their chance. What did we learn from this? Well, it takes a long fucking time to litigate a case. Don't ever get it in front of Judge Boulware. And that's basically it. I hate to say that, because I think that there's a lot of fighters that really hope that there would be some long-lasting change to their sport that left a imprint on it. But money damages isn't that bad. Again, it depends on what you were trying to get out of it.
Yeah, I'm sure we'll get into it. It definitely doesn't look like long-lasting changes coming from this. Throwing it over to you, John.
Yeah, well, I'm going to after we all say what our instant reactions, I'll get back to that, because I think there's something really interesting that we talked about on this show, but we've kind of ignored how major of thing it really was event, and no one and everybody else seems to have ignored it completely. We should really toot our horn. We've talked about it more than anybody. And I will
We
say
deserve
too,
a little bit of horn tooting today.
we
You
do.
can toot your horn. I don't.
No, I mean, when people talk about we've been with this case the entire time, I want to point out, not only was I there the day they filed the complaint in San Jose, me and Brent Brookhouse broke the story that this was coming. We did a panel discussion months before about the possibility of it, UFC being a monopsony, months before the case. And maybe I'm mistaken, but I think my Google alert that something was filed allowed me to report it first before anybody else on Twitter that the case had been settled. And then when I emailed everybody to ask, hey, what is this up? I got a link to the K10, the K8 filing by Zuffa. So I might have broken the story that it was settled even before everybody else. We were there the entire time. So listen, people, this is, no one covers us. I should say, I was going to say no one covers this case like we did, but it also might be possible for long stretches. No one covered this case but us three. So that's another way to put it. Was I surprised? I mean, no, because I went back to listen to our episode where we kind of predicted what was going to happen in November after the appeal was rejected. And I first of all, Jason had the best prediction by far because he goes, I ain't predicting anything because I'll be wrong. That was it. And I go, listen, you nailed that one. You did make a prediction. Paul thought it would go to trial. Except
although to my credit, every single time it comes up, the answer is always the most likely outcome is settlement. But yes, I did think it was more and more likely he'll go to trial. Yeah.
And I said it was going to settle for a few $100 million and some contract changes. Now we don't know. I bet you there's going to be some contract changes when this is finally revealed. The way it's laid out, it does sound like there's going to be something, but I also got a feeling those contract changes will not be game changers. They will be almost cosmetic only. It'll be going back to kind of like maybe the Francis Ngannou type contract at best that the UFC has moved far away from since then. So whatever additional information we get about what changes the contract will be better than what we have now probably on the contracts, but are not going to be like revolutionize the industry. So was I surprised? I guess if you watch the one Jimmy Smith interview where I said I don't think they're going to settle, it looks like I was completely wrong. But all the other interviews I said I thought they're going to settle just because, as Jason said, the potential when you have treble damages, the UFC's got to settle, right? Almost got to settle. They almost when you have that on the table. They don't. At least they didn't have to worry about injunctive relief. Made it a little different. That maybe they might hold out because the threat's not quite as great now. But that treble damage is going to make them settle. On the plaintiff side, as Jay talked about, these guys are spending tens of millions of dollars. I don't know what it is, but I was talking to another attorney and they were talking, there's 4 firms, dozens of guys, thousands of hours per year. They are probably sitting on $50 million minimum, cutting the expert and stuff costs that they've spent. They might have spent $100 million. I mean, one thing, Zuffa inundated them with paperwork. So they might have people working nonstop, spending twice what I thought they did. So they might have an unpaid bill of like $50 to $100 million they're sitting on the attorneys. So people are like, well, they should fight on forever. They're not going to sit there and go, if they had gone for injunctive relief for the next case, we are talking 3-4 more years minimum, not maybe 5-6 with delays. So 30 more million, $40 more million. That's just a massive risk for these guys to cover. And so I don't think they're going to do that. If the offer was good enough that they could compensate the fighter something and get the return, they have to take it. Otherwise, they're potentially eating $100 million in costs that they're never going to recoup that they put into this. So I knew that they'd have to eventually settle. So I think, but I do have to take some blame. I think the general reaction of the public has been very like, oh, I can't believe this happened. And I always thought, well, that's kind of weird considering how much we talked, like it's obvious they're going to settle at some point. So then I watched the interview I did on like Luke Thomas and I went over and I could see why people are like kind of stunned is because I'd go over like these fighters, they're asking for 800 million to 1.6 billion. It's going to be trebled and they're asking for injunctive relief. And I'm thinking people got so caught up on that, they didn't keep watching the rest of the interview where I go, but that's why it's most likely the UFC will settle. And, best case scenario, I think I said was like $500 million they'll end up paying the fighters and some contract changes because the risk is so great for both sides. So I can understand why you get caught up in those big numbers and the big event, what's possibly going to happen. But I guess when you see that, they ignore the part where we say the most likely is going to happen. And, I should have started with the most likely, but if I started with that, they would have stopped watching the show because that's the excitement level's gone. So to get long answer short, I was not surprised, but I can understand the disappointment in people because it is not going to change the industry. And if this had happened back when it originally should have happened, when the judge said he's going to grant it, we're going to go to trial originally 4 years ago, we actually would have probably thought, wow, that's a pretty good settlement, 300 and some million, for the league class. But because it didn't happen then, and 4 years later, the UFC's revenue and profits and everything have taken off so much more since then, and their control over the market's gotten greater. I think people look at it like, well, that didn't do much, and understandable because honestly, it didn't do much. Although the pool of fighters will probably get paid, they'll get something. It'll be not nothing. I'll say that.
Yeah. Okay. All right. And let me sort of share my perspective on all this, and where from the beginning, right? We were always saying settlement is the most likely outcome, but more recently, since it went so long without settling, kind of like what you said, John. They could have done it, 4 years ago or something like that. I started to think more and more it was going to trial, especially with both sides so entrenched in their positions and truly believing they were correct. But a couple of things I did nail that I will share with everyone. I was constantly telling everyone, warning everyone in advance that settlements are usually disappointing. I don't think anybody listened to that, right? Because they're like, 335 million, that's it, right? So I was telling everyone they're usually disappointing, and I think we're going to find out on the contractual changes side, most fans will be very disappointed. That's my guess. And where we talked about where the hangups were with settlement talks, I've been saying constantly it's probably over the money, which it seems like it was. Because based on what Nate Corey said, it looks like we're hardly going to see any contract changes. And it was about them coming to an agreement on the money, which they finally did at $335 million. And I think what I didn't appreciate enough was kind of what one, the role of the mediator, and two, the most recent motions in limine, right? That was again a situation where the UFC, I think, had like 2 wins. The one thing that I called the dumbest element of the case, they won on that, and then
What was it? What was the dumbest element of the case? What was it? What was
it was that you're somehow being anti-competitive by not sharing your video with competitors, like so that they can promote a new fighter. Dumbest elements of the case. One of the dumbest elements of the case. But now I lost my train of thought. Where was that? What happened in the motions eliminate stage was the UFC was pretty certain, I think, that they were going to get post 2017 into the trial, so they could talk about all the money that one championship had got and that PFL had got and the statements they had made. And I don't know if they would be able to have those executives testify or not, but at least that part on the case. And then they were trying to get sort of pre-2010 things excluded, and the judge was like, no, everything from back in the day is in. Every single thing is in, and nothing, and it's a time warp, like July of 2017 doesn't exist. So I don't think I appreciated enough that. But I think also, to me, the mediator played a huge role. This is a retired judge who's been through this before.
What's his name?
And I think, what's that?
What's the guy's name?
I don't know the guy's name. I just know it was a retired judge. I don't know if we heard it or not. I can't. I was trying to look before. Huh?
Was he an old white guy?
Don't ask me that.
Do we know how?
Do
we know how long? Sorry to interrupt. Do we know how long you were seeing the mediator? Because I remember back at the beginning of years ago that there was some alternative dispute resolution stuff that they had signed up for that they told the court. And part of me was saying, was that the mediator? Because that's where I got confused. I thought that would have been they'd gone to mediation back then, but maybe I was mistaken. So
all I know is in the pre-trial stuff in that schedule they had, they talked about the start of mediation. It was like in February or early March or something like that. So that part was new. But that you've got a judge who's gone through this before who can just be honest with each side. right? And the thing I've been saying lately is the plaintiffs were going to walk into trial with the optics fully on their side. I mean, we could go over all the things, right? The Joe Silva emails, the Dana White, Lorenzo Fertitta emails, cutting off oxygen until they tap out. The Joe Silva saying, you know, what is it? If they turn down this offer, we'll put them on a prelim against a tough fighter. The Mike Mersch email, right? Saying, and you never get out of your contract, right? All that. The Pride lawyer saying, this is why you bought Pride. They have all the optics on their side. The fighters that, when you compare them to NBA and NFL, don't make that much money in a relative sense when you compare the two, right? The UFC becoming enormously profitable, but the UFC, again, this is me having done this stuff before, had the economics on their side when you're talking about this wage share and all this other stuff, and that winning your fight doesn't make you any extra money. And I could go into a bunch of different things. The output's somehow been reduced. So the UFC was going to have the economics on the side, but I don't know how much the jury would appreciate that. So I think the mediator did a good job of explaining probably to the plaintiffs how lucky they were to get Boulware, who didn't understand anything about economics, and the UFC, like you guys were mentioning, thinking about what happens if they lose, and how the hell are you going to post a possible $4 billion bond just to even have the right to appeal? I mean, would Judge Boulware go at the high? Who decides damages, the judge or the jury? I don't remember.
The
But
jury
would they go
does.
at the high in the range, and then would Boulware triple it, and then
The jury decides damages. The
Yeah.
judge does
Okay.
injunctive relief. So,
Okay.
but
Well,
I mean, they could have done a jury trial. I mean, I think you're just interrupting. I think your model,
Yeah.
your part about the regression being a big thing would have been much bigger normally in a jury case, but and not a jury, but in a bench
In a
trial.
bench trial.
In
Yeah,
a bench
yeah.
trial would have been much bigger because the judges generally are more. I just don't think regression models are something normal people
Care about.
understand at all. But I will say this.
No, I agree.
According to Zach Arnold, we all know there was mock juries, and we talked about the demographics of mock juries. According to him, independent contractors were the most resistant to the trial. So it's possible, and I don't know if he was talking about the plaintiffs or defendants mock trials, but it's possible that either party did some mock trials and got independent. And I could even believe it. There's a possibility independent contractors are the type of people that you see on Twitter, like they shouldn't have signed the contract if they didn't want to do it. So Uber and Lyft drivers might have been like the people saying, hey, if you don't like this deal, just don't sign the contract. So it's possible that the plaintiffs went in there going, fuck, I did not know that there's a group of people, a large pile of people that are that anti to this storyline that we built. So I think that's a possibility as well. Sorry to interrupt. Keep going.
No. I was basically done, right? But I was basically
show's
saying
over.
I think the mediator did a good job of helping the plaintiffs see how lucky they were to have Judge Boulware, who, in my opinion, does not understand economics.
Okay, I'm gonna
But
cut it in a
Huh?
sec. Go ahead. Go ahead.
You better
Finish-
not have
finish
a
your
case
thing.
in front of Judge Boulware. That's all I'm
No,
saying.
finish your
it's
thing.
true. The guy literally
Oh.
in his order was like, oh, and this expert witness supported this methodology in his own research, and here's a citation to two papers the guy had nothing to do with, and a consulting project. It's like, what is wrong with you, right? But but then for the UFC, realizing how dangerous it was that they could lose. And while I think they had confidence in their case on appeal, because that's when regression modeling and that sort of stuff does go in front of knowledgeable judges, that to get there, you had to post that appeal bond. And how are you going to be able to do that depending on what the damages come in at? So
I mean, it is hard though. It is hard though. It's harder to overturn a jury verdict than a bench trial verdict on appeal. That's one thing I've learned. So that's also a risk for the UFC. It's like, but
yeah. So I will tell you a little bit about mediators. They pay a lot. Like I just told you, you could get paid $25,000 a day. It's the greatest job if you're not if you're a retired judge, because why be a fucking judge? I mean, I guess if you're a federal judge, you have your job for life. It's Article whatever 3. But you don't make as much. You make what? You tap out at 200,000, whatever. You for a mediator, and I am at the age where people of my ilk, who are my age, are ready to become mediators. You sit there you fucking look at some shit. You kind of go, you tell some war stories. You impress people like Paul Gift, and then you beat both sides down with their case, and just look at the case. When I've done mediation, all it is the judge just says, well, what's your bottom line? What's your bottom line? Okay, I'll be back. And then they leave, they go to the other room, come back. It's a bunch of bullshit, but they get paid really well. You could go to like 1 week a month and make $100,000 each month. It's the biggest scam in the world. My God. So, I mean, I get it. Now off my rant. I get it.
I don't want to make you even madder, Jason, but someone put me in touch with an attorney that does antitrust cases, class actions and stuff.
Yeah.
And I should get permission before I could say his name, because maybe he doesn't want to be known, but he put me in touch for like background. And he was saying the mediator, this 500,000 to $1 million, that someone that's specialized for this, it's an absurd amount. And so people are going to wonder why the bill is so high for this case.
So I guess they do deserve the amount of money that they will get paid, but it's an obscene amount of money to just go in and read the stuff and just say, I remember in 1995, this kid came in here and tried to do. And so based on that, I think you should come down $100,000. It's ridiculous. It's ridiculous. There is no real rhyme or reason. I mean, I get somebody's going to try to explain to me, but fuck you. I'm set in my ways. Someone's going to explain to me like how this is some sort of, well, technically, Jason, I come in and tell you a certain amount. Okay. Both parties did mock groups or trial groups, or they talked to people adverse to their issues, and they talked about what their strengths and weaknesses are. So they knew coming into the mediation what their strengths and weaknesses are, right? The mediator comes in and argues with them a bit, like kind of me and Paul. We argue, blah, 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 blah. And then at the end of the day, they're just going to give you, what's the number? Give me the number. What is you're leaving today number? And if the parties are saying, okay, we're willing to come down to 400 million, okay? So we'll limit the contracts to 4 years, 400 million. Let's see what they say. And then the guy will come in there and say 400 million. But let me tell you this: that's not their best and final. And remember, you got all of these costs hanging over. You got a firm to handle. And then, whoever is in there going, oh, let me think. Will they take 335? 335. Well, I mean, I don't know. I don't, and so the mediator pumps himself up like, I don't know. This is going to be hard for me to do, knowing that he could get that number. And so they'll go back to Zupa and they'll say, oh, they are really strong. Remember treble damages. Treble damages are bad. 335 would be a steal for you guys. I think so. And then Isaacson will probably go, you're right. Let's have a glass of what is that, tequila? Let's have a glass and toast this. And I don't know if Isaacson's a tequila guy. That's how the mediation happened. And the mediator.
Well, let me jump in on the 335. I think the plaintiffs got more than I expected them to get. And remember, from the UFC's perspective, this is literally like their adjusted EBITDA last year was $756 million. So this is like of last year, like 5.5 months of that. And you have to think of the fact that when you do this, you're eliminating all of your expenses for the rest of trial. You're eliminating all of your expenses to appeal after that trial. And you're eliminating all of your expenses for the whole second lawsuit, which is Cajun Johnson, which was going to go after that. So all of those are now gone. And even if you forget about that part, it's only 5.5 months of your adjusted EBITDA.
Their net income last year was 339 million, I believe. Yeah, just 4 million over the. So yeah, it's covered. It's going to be payment over 2 years. So it's not even one. 50% of their net income 1 year, 50. They don't. they have a credit line of 455 million that they can spend whatever the hell they want on. So that's covered. I remember Gray Maynard reminded me, and so did Kurt Emhoff, that I told Gray Maynard it'd be settled for 300 million. So I'm gonna take credit, but I thought that the settlement would be slightly above that because of the credit line. I thought, well, the credit line's there to pay it. Let's put the credit line will be what the settlement is. But I'm going to bring up something that we talked about in the past, and I think had a major impact on this case in hindsight, that even though we talked about and said would have a major impact, I don't think we stressed how major of impact it would have, and everybody else ignored. And that is the introduction of the OLN case in April of 2021, because I'm going through the case again in August of 2020, August or September 2020, after several delays because of COVID, Judge Bulwart indicated he is going to grant class cert. December of that year, he had a hearing on, a virtual hearing. He said he granted the orally granted the class cert for the bout class. Then he ordered they're going to have a hearing in April of that year where he was going to issue the written opinion before the hearing. The day before that hearing, UFC introduces the OLN case. The judge later said he put the case on hold to wait for that OLN case to finish. If that OLN case doesn't take place at that time, I'm not sure we even get a Johnson class. I can almost guarantee you that that we would get injunctive relief for the Lee class. And so we'd go on trial later that year with Lee class having injunctive relief with them, that the many members of the Johnson class had probably been rolled into Lee. And eventually, if there is a Johnson class, in other words, the Lee class would not have that problem. It'd be a much bigger cudgel. They would have gone into trial quicker and with the cudgel of injunctive relief for their case.
But so what you're saying is things would have sped up, right? You're saying there wouldn't have been this. Oh, John's probably got a cat issue. It sounded to me, Jason, like you was saying we got Cajun Johnson because of all these delays.
Yeah.
And what we do know is they definitely didn't get injunctive relief in Lee because of all the delays, because the UFC's contracts had changed so much over the years. Because there's a second
class was introduced, or because there's a second class introduced, the Lee class lost standing, and they couldn't do injunctive relief for Lee.
No. I want to correct you on that. I was in the courtroom when they were arguing this, and Kramer was saying, I just read the transcript again.
I just read the transcript again. They could not, because none of the Lee class were active fighters when the Johnson class was filed.
Yeah.
They cannot do injunctive relief for those group of fighters.
For Lee?
For Johnson.
Oh.
For the current fighters.
I don't recall hearing anything like that. I don't know. I mean, I think we're talking a little bit about semantics, because the judge was literally like, you have to decide if you want to do it for Lee, and if not, we'll do it for Johnson.
Go back to that transcript, reread it, because what he's saying.
I was there.
Yeah, no, but reread the transcript. I know. What he's indicating is we can do the Lee class, but you're not going to get what you like because it's not going to impact current fighters. Or we can do the injunctive relief that impacts current fighters with the Johnson class, but then we got a delay to do discovery for that.
Yeah, I think
which means
that's correct.
Probably 4 years before you get to trial again.
No, well, what I remember him saying was that we can have injunctive relief in Lee, but we're going to have to do discovery then.
I think that you're saying the same thing.
Yeah. Well, yeah. and they're like, you have to make, but the UFC was saying we can do discovery fast. The UFC was like, we don't have to postpone the April trial. We'll do it super quick, right? And Boulware wasn't down with that. Well, but anyway, I think what you were trying to say, John, regardless of that detail, right, was that that thing in 2020 led to Cajun Johnson and led to these delays that messed with injunctive relief. Is that what you're saying?
What I'm saying is, because they delayed that class cert, because they did that, when July 1st hit 2021, they were going to start having fighters that lost that no longer, but the statute of limitations were running out. They were going to get prejudiced in the case. So they had to file a second case. If they had done class cert, they could have gone in and said, we just want to do a few months of background discovery so we can do research, so we could add these additional fighters to the case when we go into trial. You're allowed to do that. In fact, they even during the hearing in November, they talked about that's what the UFC attorney said they expected to happen. But because they filed a new class, now guess what happens? That new class, you have to be a current fighter for that class to have standing for current fighters. Otherwise, you don't have standing. You can't do an injunctive relief if you're not a current fighter. So they had to been fighting at the time they class that. And the UFC, who after the Trump administration signed an amicus brief and sent it to the Supreme Court, and the new Gorsuch, the new Trump appointed judge, was the deciding vote. They decided to make constitutional class action waivers and arbitration. So as soon as this new class was introduced, who you can't force class action waivers and arbitration on already people in litigation, but now we have a new class that hasn't gone anywhere yet. They started introducing the class action waiver contracts. So this whole new class of fighters has class action waivers. There's no damages with that group. And so you're now in a situation where we have a class we're going to go to trial with, right? That stops in 2017 that we don't have injunctive relief for. So we can't use that as a scare tactic, cudgel to threaten the UFC with. And the second class coming after them that has injunctive relief, they have no damages because they introduced a class action waiver because they have no members in that class that can sue.
I think we've talked about it before, and that makes perfect sense.
But we talked about it on the show and everybody kind of ignored it, but it just shows you the loss of why there was so few leverage, I guess, why the case unfolded the way that it did, because there wasn't leverage on the league class, and the UFC is like, we can pay this, and now we don't have to worry about anything. There's no real threat from this class. Let's just pay this $335 million and just get rid of both of them, and we don't have to worry about class actions in the future because everybody's now signed a class action waiver.
Yeah, see, I took it as a sign that the plaintiffs were. I think we're seeing that. And there's nothing wrong with suing someone and saying you want to get money, right? But this wasn't about changing the MMA landscape, I don't believe, unless they could just somehow go to trial and win. But they had the judge that gave them the decision do you want to keep injunctive relief, and it's going to delay the Lee trial. So they could have kept injunctive relief in the Lee trial. It would have delayed it.
Yeah, because
and they chose not to do that and then settled. Right, which again to me signals it's about the money, not the contract change.
Wait, okay. How long, if they're going to do discovery in the Lee case for injunctive relief, they got to do discovery that means they're doing discovery for the Johnson case. Discovery, right. That means that discovery takes 2 years, and then you got to have hearings and analysis and stuff to contest those hearings and analysis. That's 2 more years minimum. That's 4 years.
All I'm telling you is when it came to issues with contracts, I don't know what the plaintiffs would have agreed to, but the UFC was willing to do it by April this year.
That was never realistic.
That's what they say.
Well, I'm just telling you.
That's what they say. But as soon as you do that, you open up discovery. They're like, well, we got to do all the discovery and the whole.
Because
UFC, I don't even think they produced. Did they even give any discovery yet to the plaintiffs at that point?
That I don't know. I'm wondering about that because how are they going to pay out fighters based on their pay if they don't have discovery? Now, some have signed class action. Well, that's going to lead us into something else because some have signed class action waivers, right? But the ones that never signed it but were in Johnson should still get paid, right?
Yeah, I just don't know how many that is because if you signed a class action waiver, that if you're in the Johnson class and let's say you fight the first few years in Johnson class, then sign a new agreement with the class action waiver, your earlier bouts are eliminated. You're completely eliminated from the class.
But it would still be able to be a set of fighters like a CM Punk who fought in 2018 but never fought again.
It's going to be a very, very small because I started asking around about, okay, half the fighters probably signed the class action waivers, but because a lot of those fighters had fought earlier, that removes 3/4 of the bouts. But also because the higher ranked, better fighters, the more valuable fighters are the ones more likely to sign that. You're probably eliminating not just probably 80, 90% of the compensation of the class.
No, I hear what you're saying, but there are still fighters who didn't sign them. And if you're allocating based on pay, you have to have some information about their pay, right? So there's got to be.
That might be what they're settling right now.
Yeah. But that leads me into a question for you guys is I mentioned this to John on Twitter, X, whatever it's called, is that like imagine you're an Izzy right now, right? And you're a Cajun Johnson period fighter, and you made, you know, in MMA terms, pretty good money, and you would be getting nothing from this, like zero. What would you? And Eric Kramer, if you guys don't know, is plaintiff's attorney, lead plaintiff's attorney, is on record. On record, you can find in a transcript saying we don't believe those class action waivers are valid. What would you be doing right now?
You go to arbitration. That's all you can do.
With Eric Kramer?
No, you go to
who?
arbitration with UFC. You opt out. You have, if there's a class, whenever there's a settlement, the fighters have an option of dropping out of the class and doing their own lawsuit, doing whatever they want. He can say, listen, I'm no longer part of the class, even though he's a class action waiver. You can't take part of it. He can go to arbitration. But now the problem is he has to sign his own econometrician to do a regression model for himself. And that's costs a fortune to come in and prove that there's antitrust damages.
Wouldn't you be negotiating with the plaintiff's attorneys right now? I don't know. Maybe I don't need.
Why? He's not part of the class. He's not allowed to be part of the class. Now, maybe the plaintiff's attorneys are going to say, we're going to make we're going to give every fighter in it, even if they had a class action waiver, some small amount of money compensation.
No,
maybe they'll do that. But that's kind of unfair to the other fighters, because they negotiated a pool based on who was available, not on, you know. So now you're like, we only have a smaller pool because so many fighters were eliminated, and now we got to pay the guys that were eliminated with the pool we got. That seems unfair to the guys they're.
Yeah. That would not happen. That would not happen. If I was Izzy, I'd ask Eric Kramer what he was talking about. I mean, realistically, if he said that if the class action waivers are not valid, I would ask, how are they not valid, right? Because that potentially could be the next lawsuit, right? That because if they're not valid, then, you know, they should be receiving some. I mean, they should have their ability to sue if they wanted to. But again, Izzy would have to hire his own attorney, hire Eric Kramer, hire his own attorney and whatnot to do that, and that's a lot of money and a lot to do with the UFC. And I'm not sure if arbitration would cover that. So I mean, I know they could probably go to arbitration, but I don't know if they could cover that. That is covered, the interpretation of the contract.
So what I'm getting at is, couldn't Izzy, like, who decides who gets how much money? The plaintiff's attorneys?
I think that is the parties, right? The settlement. Oh, I mean, I guess no, excuse me. It is the plaintiff's attorneys that are head up the class action. You know, when they certified the class, they certified the law firm that would be lead in this.
Right.
So they were the ones that decided to take the 335 and whatever other accommodations that they would receive. And then as far as, you know, maybe got your guy Hal Singer to come up with a way to disperse that money, but obviously it's going to be based upon how many fights, how long you've been in the organization, that kind of thing. Right.
But if Izzy is saying, I'm a part of the Cajun Johnson class and you are not going to give me any money because you, Eric Kramer and team, are saying that I signed this class action waiver, but you're also saying that it's an invalid waiver, wouldn't the dispute be between Izzy and Eric Kramer and the team?
Bro,
Wouldn't that be the dispute?
I'm not trying to make cases for people.
That's what I'm thinking. I'm like, why aren't they lawyering up and going after the negotiation of who gets the money?
No. I mean, well, no, because are we talking about the Lee case, or are we talking about the Cajun Johnson case?
We're talking about the settlement of both cases.
Well, I guess that's one and the same. So he would have to. I mean, I think what John said is he'd have to hire his opt out of the settlement and get his own lawyer, right? Because you could opt out of the settlement.
But his whole deal, what the argument I'm saying he would be making is, I'm a part of the settlement, and you plaintiff's lawyers are excluding me because you're saying I signed a waiver.
No, the UFC, that's UFC saying he signed the waiver.
That's UFC saying he signed a waiver.
You're saying
that's everyone saying he signed a waiver, but the plaintiff's attorneys.
Did Eric Kramer say that he can't? I mean, you said Eric Kramer said the waiver is.
Eric Kramer said in a hearing that he did not think they were legal to stand upstanding.
Right.
Now, what Paul is saying is, because Eric Kramer made one statement in a hearing that he has to go to court on behalf of Adesanya and get the Supreme Court to overturn the previous
No.
decision.
That's not
No,
what I'm
maybe.
saying. What I'm saying is that if it's the plaintiff's attorneys who decide who gets how much money and they don't believe these waivers are valid, but yet all of a sudden they're going to say, hey, these fighters don't get any money because they signed these waivers, that seems inconsistent. And it seems like a fighter would dispute that with them.
They may be, but I guess my question is, did they investigate it after making that statement? Because my understanding is they did not learn about those waivers until relatively recently. In fact, I don't think they learned about them until we posted articles about them. So if that's the case, and maybe he made a statement, I don't. If they investigate later and found shit, we're out of luck. These are upheld by the law, the court. There's precedent. Then that changes things.
Well,
But
I
he
would
could
think
also, but if he does think they don't stand up, then yeah, he probably should challenge them as on behalf of the class.
I mean, yeah, I would think that that would be a part of the settlement, is determining whether or not these class action waivers are valid, right? So they would include, they would assume they include Izzy, but they would have to have that discussion with the Zuffa attorneys, or at least maybe the mediator. Maybe your guy, the mediator, came in and swooped in and took a look at that and said, "No, this is invalid. We got to pay Izzy. He's a part of this." Or maybe
Guys, all I'm saying is
or maybe he didn't.
There's $335 million out there. And people from 2010 to 2017 are getting a chunk of that. And a lot of people from 2017 to 2024 might be getting nothing.
Yeah.
That's a powerful incentive to be like, I want to get some of this. That's all I'm saying. I don't know what's going to happen.
Yeah, it is. And that's why they probably shouldn't have signed those waivers, but they had to. That's the problem. That's what we talked about. The waivers would take them out of the case. And now it probably did. It probably took, the vast majority of fighters from 2017 on out of the case.
And the only additional element I'm adding is the guy who decides who gets what has said is not valid. So it makes for an interesting plot twist here. That's all.
Don't besmirch.
I mean, I would imagine that he said it's not valid at the time because he wanted to challenge him to increase the pool.
Yeah, of course.
Of guys available. But that doesn't mean he really, doesn't mean they really aren't valid, because the Supreme Court has upheld that class action waivers are valid. Now, the other thing, the UFC could be nice and say, you know what? We decided that those weren't valid. We shouldn't have done that.
No,
that's not happening.
So it's kind of, no, I'm just saying it's weird that the plaintiff's attorney is the one that has to find a way to round this loophole, but the defendants that inserted it, there's no criticism for them here.
Well, maybe your mediator here could have decided this. Maybe he said,
Jason's all about the mediator.
Let's just waive this. Hey guys, I'm the mediator. Let's just waive this stuff. We'll waive the waivers and include these guys in the class. They could have done that. They seriously could have done that, because it is the mediation. Maybe there was you have to think that all the attorneys involved, and I make light of this just for entertainment's sake, but all of the attorneys involved were well prepared to get into this mediation with this well-esteemed mediator, whoever the fuck he is. Anyway,
how do you know he's a he?
Oh, come on.
Yeah, look at that sexist guy. Look at that.
Let's be honest.
Just saying.
I'm sorry, but it's true, folks. And I don't want, okay, well, maybe not, but it's probably a dude. I'm just saying. Anyway, so he could have just said, he hammered that out with Zuffa lawyers and said, hey, I know you guys have had them sign these waivers. I see some legal ambiguity in this, and maybe this doesn't hold up in court. So maybe we just settle it right here instead of having to fight over this with the Cage and Johnson class, because I would assume that Kramer's guys and gals, the attorneys, the law firm, would say, hey, we both have to be settled today. Our number is based upon both being settled, and the people in that class have their waivers waived, and they are a part of the class. That could have happened. As a mediator, you could mediate that and just write it up in the settlement. Write it up like people write it. They type it out, but type it out and just say that's a part of the settlement. Is that altruistic thinking? You betcha. But I mean, maybe that's a way around it so people like Izzy get paid.
Yeah, the reason I'm pretty confident that they're still not part of the class. I mean, who knows? Like I said, they could send out a check, a small check as a token for everybody, but which I don't think. Again, we goes back to probably be unfair to the other class, but it's 325 million. That tells me right now that the rest of the Johnson class, that settlement, the rest of the Johnson class is not in part of the settlement because you think of the leverage. You're going in and you have treble damages. That's the fear of the UFC right now. And then the other fear is injunctive relief for a class that has almost no damages attached to it because everybody has a class action waiver, the vast majority of them. And it's 5 years down the road before you get that done. Right? That's not a massive piece of leverage there. The leverage is the return, the amount on the league class. I'm guessing the vast majority of that compensation, that settlement is set for the Lee class, and much smaller for the Johnson class. And for the Johnson class, it's only the few fighters that didn't sign the waiver because the rest are not part of the class action. They're not members.
So a question, how do you not sign a waiver?
You can't. You don't fight for the UFC then.
So that's like, I mean,
how do you not sign a waiver? So how do you sign a waiver?
No,
double negative.
Yeah, I know. I'm an attorney, but like,
you take your hand and you go.
What I'm trying to say is like, so Cajun Johnson's lawsuit, the people that in it did not sign a class action waiver, but you said that like after Lee, they made all the fighters sign class action waiver. So how do you not sign it?
Oh, you had an existing Lee contract and then you got cut or you left the promotion or whatever, right?
So you had fights still left over in Lee, but you did not.
Like CM Punk, or you signed like first fight in Lee,
or you signed one of the Ngannou class, contracts at the very beginning of the class when they did the first changes.
And John would know when it happened. Yeah. Or I go to CM Punk because he had one fight in Lee and his Mike Jackson fight was in Cajun Johnson. And then I'm assuming he never signed a new deal.
He had a 2-fight deal he had a 4-fight deal, didn't
he? He could have had a 4-fight deal, but he never fought again. Right. So I'm assuming he never had to redo his contract.
Sense. Yeah, that makes more sense. Okay.
Yeah. So there's like a handful of those people, right? Who are still getting paid.
Right. Gotcha. Okay. But, that makes sense.
Yeah. Yeah. And I had like all these questions now, and now I totally forgot what I wanted to say. Where were we at with this? That kind of leads into a little bit, unless there's another angle you guys wanted to take with this, about how you kind of think where we're at now with UFC contract. Let's assume that the settlement has either no changes to UFC contracts or very minimal and was more about the money, right? The $335 million. And we're at a point now where both antitrust cases are over. And based off what Nate Corey said, it seems like hardly any changes to contracts are coming. And so what do you think the ultimate impact of this was? Because last I checked, 3 or 4 months ago, John is still constantly complaining that fighters can't go anywhere and other promoters can't compete. And right, because one thing the antitrust lawsuit did do is it did change UFC contracts incrementally, and that's another thing I mentioned along the way. I was like, antitrust cases make these small changes because the companies don't like these lawsuits and they'll change certain things. Right, a big one like when Visa would get sued, there used to be this no steering rule, and they got rid of that. For people who are listening, that's the debit or credit question that you get sometimes, and they started allowing that. So these changes, there are incremental changes that got made, and it helped Ngannou. But I think listening to John talk, it would sound like he doesn't think much has significantly changed, and now both antitrust lawsuits are over. And if anything, the UFC is more insulated against future antitrust lawsuits because they have made changes to their contracts. Their right to match period is 4 months instead of 12 months. They have a 5-year sunset on a lot of fighters, not all fighters, but a lot of fighters. They've made these changes from what they used to be. So what do you guys...
The change that insulates them from future lawsuits is the waiver to sue them on future lawsuits.
Well, that too. Oh, yeah.
That makes
no. Wait. No. Just let me remind people, though. Competitors are still allowed to sue. Sue, and yeah.
But competitors don't. The competitor that's left is PFL. PFL does not want to compete with the UFC. PFL wants to create a miniature UFC, a Pepsi to their Coke, where they have complete. I mean, look at their contracts are just as bad. They're doing the same thing. They want to create their own walled garden over here that has a fan base. They want to get a few big names to come over and get people interested in PFL, and then say, now you have to sign with us, and you're trapped with us with our system of tournaments that bring fighters in. And we don't have to compete with the UFC. That it's its own. It's the WCCW or WCW, whatever the pro wrestling one, against the WWF, right? It's listen, I'm an AWA guy. Vern Gagne should have won the Wrestling Wars. We wouldn't have any of these problems. But that's what they're trying to do. They're trying to make a self-contained stovepipe that that they don't have to compete at all. They want to create their own Pepsi. So I don't expect PFL to do anything. One the same. You're not going to raise capital by claiming we can't compete with the UFC. That's the whole point is we can be like the UFC and make those type of margins. And the only way we can do that is not competing with the UFC. So I don't expect other promotions. But the UFC, they have a waiver now. And so the contracts that got much better. I complimented them. They had the best contracts in MMA for a few years, though. The changes they did, stuff no one else is doing. But now we're moving in a direction where the sunset clause is a joke. It says 5 years, but it has tons of loopholes. So I think they're going to have some contract changes back towards the what they had in 2017, except for because of the example of Ngannou. I think they keep the loopholes on the 5-year sunset, that they're going to find ways to keep guys longer so no one can do what Ngannou did.
Right. And so my question was kind of like, what do you think the ultimate outcome is about sort of changing the sport? The fight, $335 million is a lot of money, but did the sport changing aspect happen?
No, that's the part I think failed. That's the part that failed. If this happened a few years ago, we would have thought the money was actually pretty impressive. If this happened 4 or 5 years ago, we'd say,
I still think it's impressive.
Well, I mean, but not impressive that it's not going to impair the UFC's ability to do things. It's not punishment for them. The UFC is not going to look at like, we cannot do this anymore because the damages, we don't want to suffer this again. One, because they can't get sued again on this front unless the Congress steps in and changes the law. So it is kind of ironic that all the UFC, well, now you understand why the UFC supports Donald Trump so much. That waiver probably does not exist without the Trump administration. If Trump didn't win, they would not have these contractual protections. So
we'll see him at UFC 300. No
yep.
doubt.
So I got what? I'm still waiting for my credentials for UFC 300. Let's see if they come in. But
Did you ask?
Yeah, what's that? I asked for a lot of them, and I never get a reply. I'm on the pay no mind from USC. So
there's too many people there. We can't attend.
Yeah, if you're 200 people, they don't even respond to me anymore. It's not since Dave Scholler was there did I get nice responses. I give him credit.
Dave was the worst to me.
He
told me. I told you the story about how he told me that there was too many people at the Seattle media, so I couldn't come. And there was nobody there.
Oh, at least he emailed you back and told you a lie.
Fuck the Sixers.
Yeah, at least the other guys never reply to me, so I give him credit. At least he would say like, "Oh, we can't respond and stuff." He would at least let me know they got the email, that I'm not sending it to a dead account or something.
Yeah.
But evidently, I share a housekeeper with the UFC PR lady.
The UFC.
Who's that? All I know is she's the one who's always on her phone at fights, Lene, right? And every time you see her sitting cage side, she's on her phone.
I don't know her because I'm not allowed at any events.
All right.
But to get back, so the purpose of the lawsuit, part of it was you wanted to do monetary damage so great that the UFC wouldn't do it again. It would curtail their behavior, or the threat of future lawsuits would curtail their behavior, and you had contractual changes to change the industry. Neither are happening. So what's that tell you? That tells you that nothing's changing. In fact, if anything, because during the length of the lawsuit, the UFC's grip on the industry's only got better. I mean, I do find it always amusing. The UFC will always release, look at all of our major competitors, and then you come back to it a few years later, and almost all of them are gone. There's the first batch they sent the FTC, like, hey, don't investigate us. We have massive competition in this industry. All gone. And then this suit, don't come, listen, we have Bellator, we have one is a duopoly. They're a major rival. And then you're like at one has like, 8 Muay Thai fights on the next card. That's it. There's no, they're not competing at all in MMA. I don't even know if they're an MMA promotion anymore. So I find that amusing that they list a long list every time, and then half of them are gone by the time the next list comes out.
Yeah, if Trump wins, which please, dear God, no, please no. But if he does, that's a scary thought. But if he does, like, would they buy PFL/Bellator like in 2 seconds? Like, look at what we can do
No,
now, bitches.
I don't think they don't need them anymore because they got the 90% of the
Hmm.
market. They don't need it like they did
Yeah, but just to
Strikeforce
flex the
and
muscles.
but yeah, I mean the get off on a tangent. I mean, the one good thing for Trump gets in office. I mean, right now they're I guess they're only feared to be like the FTC or DOJ or NLRB doing some action right now because those three entities, all three of them looking out for they have a order by the administration, executive order to look out for labor, right? And so they could conceivably take action. But if Trump comes off and he doesn't have to, not only does he not have to worry about the Ali Act, that then they don't have to worry about DOJ,
Yes,
any sort of DOJ investigation, FTC. They don't have to worry about NLRB ruling them as employees. None of those become to be.
that's what I was getting at, but I didn't say that. Yes.
Oh,
Yeah, that all of a sudden it would be a new FTC, DOJ, NLRB kind of thing. Yeah.
yeah. Mergers, acquisitions are no longer under. Yeah. Back to the world of let's back to how it's been for a while. The consumer welfare model rules again, which is weird because Trump says he's against monopolies, but and maybe they, also you got to remember the previous Trump administration, the head of the antitrust division, Macon Delream, he was a lobbyist for the UFC, went to Trump, and then left, and now he's attorney in the firm that represents the UFC and Endeavor.
Oh, I didn't know that.
Yeah, so it's like there's just a straight revolving door between UFC's just completely piped into the Trump administration, the GOP. So if they win, it's inconceivable any actions taken at the federal level, and it's already very unlikely any actions taken. So,
All right. So, what other aspects of this settlement do you guys think are interesting, need to be discussed?
So I was just going to add that I think that the settlement would have been a little more, like John said. I think there are hurdles to this for this case overall, and you know, the fact that the pandemic hit really hurt the forward progress of this case. I think that uh, the just the shutdown of the world really hurt how this case was going to happen. And like again, Judge Bulwer really did the plaintiffs a disservice by not uh, being forthright and fucking filing that class action certification earlier. I think if the timeline for this case had been compressed more, it had been a better position to be settled prior to 9 years, 9 years down the road, 9, 10 years down the road. I think fighters would have been a little happier with what they'll eventually get. And I think that maybe there'll be more concessions. But the fact that, I mean, and this is again an indictment on the legal field of itself, is that the law takes so long to go matriculate through the courts. It's just a whole big process. I'm sure our good friend the mediator would have told them that it was clear that the Zuffa was going to hold this in court forever, as long as they could. There was no way that they were going to have little discovery. There's always discovery disputes. So even if if the Zuffa had said that they had every intent and belief that they were going to do discovery in the fall of 2023 and still be ready for trial for Lee in April of 2024, was a little bit of a tall tale, simply because there would always be a discovery dispute. There would always be more stuff to look at. There's always ways to extend discovery and make this longer. So I think that if there's anything to be learned of this settlement, is the fact that suing takes a lot of time, especially these huge antitrust cases. And I'm not sure if everyone had the not, I mean, maybe, I mean, not the attorneys, but I mean, I'm sure everyone in the class probably did not have this vision in the mind that that when they filed in 2014, that they'd be looking at a settlement maybe 11 years later, 2025, when the last payments are doled out. And I mean, and just to go back, I thought 335 was low, to be honest with you. In comparison, I thought MLW getting 20 million from WWE was super high for that level of that case. So I don't know if that was a benchmark that the parties had looked at. I'm sure it was something, but again, 335 is good just because they do get some money, but it wasn't. It's what your expectations were for this particular case.
All right, John. And how about you? I guess I can wrap it up with my thoughts after that.
Oh, yeah. I had some good thoughts and then I lost track because Jason talked a lot. But he had good points. He had a lot of good stuff he said, Jason.
I talk too much. Damn it.
I can share mine while you try to regather them if you want.
No, really. I think the big thing is Jason, the delay, but the big delay, and I had a question for Jason because he's an attorney. He knows stuff about the law. I'm just a caveman over here. I don't know that stuff. But if he granted that class certification in April 2021, which is even then was delayed a little bit because of COVID. And if we then went to trial with the OLN case still up and appeal, would that have impacted the potential class cert verdict? Because could he not grant class cert because OLN had set a new precedent that changed the standards of class cert? Did he have to wait for that to be over before he could grant it? I guess is my question.
I don't think that he had to wait, to be honest with you, but I assume that he thought he had to wait for that to be granted. The issue that I have is that he was waiting on a case that had no certainty of when the result would happen. So if you can imagine that if they had, I mean, this is hypothetically speaking, if you had 10 cases, 10 different cases with different facts, but they're waiting for one issue to be decided by one appellate court, not the Supreme Court, but just an appellate court, which in and of itself could be appealed and overturned. You know, why wait? Why wait? They could go forward, and if the onus would have been on Zuffa to make an appeal and say, hey, wait here, Judge. We have to, they just decided OLN. We have to rethink this, that sort of thing. Because I mean, that's the frustrating thing about the law is that, you could be tied up. You could have the perfect case and have it go forward, no issues. But then there's some other case that the judge, the fact finder, is waiting for pending to decide your case. And so, in my opinion, I don't think he had to wait. It's clear that he thought he had to wait.
So, okay. Well, that's the reason we had such a long delay, right?
Yeah, and it was stupid.
And because of that, they lost the injunctive relief in the Lee case, and it started the whole problem with I mean, for the plaintiffs, that's got to really hurt because they lost probably their biggest fear tack, the thing that they could put the most fear in the UFC.
The biggest leverage that they have.
We're going to go in there with all the fighters receiving damages, none of them out of the class. And we have injunctive relief. If you don't go through this, we can change the business model. We know how important it was because Isaacson even said in interviews that damages is no threat to the UFC business model, that the stock market should not be reacting that way because injunctive relief is not on the table.
All right. And I mean, I think Jason had it right there that, yeah, clearly when you saw his rulings after the fact, whether OLN happened or not, he was going to certify the class, right? Because but I think he felt he has to wait. But again, I'm coming at this from the perspective of an economist, and I just want to remind everyone listening: the antitrust cases, while there's clearly a human element, a huge portion of them is the economics. Antitrust is the economic concept, and the plaintiffs were blessed blessed to get Judge Boulware, blessed to get him. And so, the 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 main takeaway I have is I just want to read something to you. This is from the Freakonomics podcast recently. It's just a quick quote here. He goes, "We have a lot of what's called robustness checks, which means we're checking different stuff to make sure that we think the answers are as believable as possible." And I know this is stuff that people don't care about, but there was a significant portion of this case that had non-believable stuff, and that was going to have to go to trial. And now plaintiffs got $335 million, and that does not have to go to trial. So I'm one of the few people who thinks it was more than expected, right? They got a good payout. And that's the reason why, is because I'm focused on the things that nobody else cares about. And every time I bring it up, you guys are like, yeah, whatever, yeah, regression models, yeah, this, that, and the other, right? But remember, you have to prove anti-competitive conduct and an antitrust injury. And part of that, the way that plaintiffs were showing that the UFC suppressed pay was with something that in order to believe it, you had to believe that, I'm just going to go back there, that winning your fight did not increase your pay, even though we know that 94% of fighters have win bonuses. And then there's a whole element that when he was on the stand, the evidentiary hearing, he talked about a very highly correlated relationship, that it was in the 0.2 range, somewhere there, which no one in their right mind would ever say. Like, to me, that's possible perjury. And you had that going on there. And all of that was going to come out in the trial. So all of that got avoided. $335 million. The plaintiffs got a great deal, and they won. I think the UFC won as well. To me, I was talking to Kevin Aoli about this, and I was like, Kevin, it's going to sound like a cop-out, but I think both sides won. They truly did. Plaintiffs got more than I expected them to get. And the UFC, right, this is not that big of a deal to them. We have to find out what happens with contractual changes at the end of the day, but it doesn't look like many of them are going to be there, right? So this was a huge, long, drawn-out process to get some money, right? I've called it a money grab, but I don't think they were interested. I think they would have gone after injunctive relief, but that's not their primary goal. We saw that by what just happened. The hang-ups, it seems that it's clear now. The hang-up was money. And they finally, the good old mediator got them to agree on a monetary amount that made this all go away. Jason's best friend. I think his career goal is to be a mediator when he retires.
No,
that's my guess.
I probably people will look at this podcast and disqualify me.
I mean, obviously, money was a big part of it, especially for the attorneys. That's what they're doing it for. I mean, they're not going to walk away from a case and be out. Oh, we're out $50 to $100 million in labor, and
That's
be
not how you
happy
really
without. It's like, wow, what a great. They're not going to say, oh yeah, we would have shot down, we would have taken no money to get injunctive relief and been out tens of millions of dollars that we put in this case. I mean, I don't think that's conceivable by them. I mean, I know you can tell, Fitch and Macy and those guys and Kung Lee, they wanted injunctive relief. That was their primary goal. And you got to convince, the plaintiffs can go in there and tell the judge that we don't agree with the settlement, the named plaintiffs. And I don't get that sense they're gonna. So I'm sure they knew. Yeah. That's why I think that the idea that injunctive relief would have taken years more, that it was the Johnson case. So
I'm sure they had a talk with, that's what you do with your clients all the time, is that you have to mitigate expectations about what's going to happen. And it really sucks for the fighters, the ex-fighters that wanted to leave at least some sort of lasting something better off for the industry than when they fought. Like, so the fact that it won't happen in this particular case is unfortunate, but again, the realities of litigating is just tough.
Also, the theory that they had behind this has been completely changed, because the whole theory was, if the UFC doesn't change their behavior, we just sue and we collect some money in the future and do it again in the future, get those fighters more money from a lawsuit. But now that the UFC has changed, that window is not even open. You cannot compensate any of the future fighters for it. I will say it is interesting, just on pure nerd. One thing's interesting is the reaction when fans in MMA world is this was a disaster in many ways. But I have a lot of people I follow on Antitrust Twitter, which is a real thing apparently, and the legal guys, and they all thought they were surprised at the reaction because they all thought it was a big win because in their world,
That's what I said.
it's a big win. I said too. I understood why people think it's a big win. The other thing too, this is the first ever Section 2 labor monopsony case, class action to ever get anywhere. I don't think they've ever been class certified.
And it's definitely the first wage share one.
Yeah,
that too.
That's kind of there's some. I did think people were overreacting to the wage share part. The people that were worried about it because I don't think it's going to impact. It's going to not be entered into regular jobs. I think that was pretty sure. This is products that are going to be a wage share. But anyways, there was some some novel stuff in this, some kind of landmarks were done. But yeah, but it doesn't change the industry, and that's the part I think. And it doesn't. I mean, like I said, if it was several years ago, it wouldn't look bad because 335 million is more than half of all the compensation to the league class was paid by the UFC. So you're like, oh, we got 50% of the 50% for the fighters. Now, anywhere from 20 to a third of it, 20% to a third is going to go to the attorneys based on whatever their lodestar and stuff is. So the remaining, they're not going to get that much, but they're going to get, let's say, a quarter of what they made during the league period, just as a guesstimate. Which is, for a lot of fighters that are broke or have problems after the UFC, it's probably not bad to get a check like that. And this is, you got to pay taxes on it, but this isn't money that's gross. Like when you fought for the UFC, there's no trainer fees, no manager fees, no, it's none of those other expenses that go with it before you get your net. You pay your taxes, you get this money.
But we should mention, I think, you can maybe clarify what exactly you learned from Eric Kramer on this. Because it came from you, right? That it sounds like it's going to be based on what fighters earned. Which, if that happens, I mean, if you had 4 fights in the UFC and were whatever 8-8 and 10-10, 12-12 versus Conor McGregor, Brock Lesnar, Ronda Rousey, John Jones, GSP. I mean, Jesus Christ! Like when I did a rough calculation, the average that I came up with was $185,000, assuming. Again, neglecting the Cajun Johnson people per fighter. But I mean, if it's allocated based on pay, that is a lot going. And they deserve it. Because if this story of wage suppression is true, they are the ones who are most suppressed. That confirms my research.
Yeah,
right? That big name fighters got 8.5% of their MRP. Right?
Yeah, me and you talked about this before. That what we don't agree with the Helsinger model at all is that we think that the most damaged are the top guys.
Yes,
so people are going to be upset by that, but I mean, truthfully, the top guys probably deserve those. He commented and he says it's most likely to be proportional, right? That'd be one of the methods probably looked at. But that seemed like the most likely. Now, who knows? Maybe they'll have, like I said, maybe they'll do. There's so many possibilities. Maybe they'll do a bare minimum. Maybe they'll do something. A portion of it will be maybe a small amount, 1,000, 2,000 for every fight you had during that period. I'm just making stuff up here, people. Yeah. So, but the most likely it's proportionate. You take the percentage of the total compensation that was made during that period. What percentage did you make that's of that compensation during that period? That's what percentage of the settlement damages you'd get. Probably that seems to be the most likely. So, but that might reward. I mean, if you fought once and made a ton, you'd get a big piece of it. But if you fought a lot, you might compile after a while. But the guys would be most hurt would be the 1 or 2 or 3 fights. And but I mean, I don't know. I don't have a system how I would do it. I haven't thought about it that much, but that's sounds like the method they're going to use. So, but again, at least people will get something. I just don't think it's going to be. You're not going to retire on it, but it's going to be like the California pension. A little better than that. The California pension.
I mean, what? Actually, 185 pre-tax?
What?
Is that 185,000 pre-tax? Is that what you were saying, Paul?
Well, I just did a rough calculation and gave a third to the attorneys and then took 1,200 fighters and did like the average, right? But I mean, that was like a ballpark figure, right?
Here's another thing though to consider. That pool of fighters might be bigger than we think. Smaller than we think, because if it's only, let's pretend it's only the league class, because they settled on Lee. So who knows? Maybe the injunctive relief changes was all the Johnson class gets out of this. Maybe there's going to be some contractual changes, and let's just pretend no damages are being paid to the Johnson class. all the money's going to the league class. Well, that's 1,214 fighters, but it's really not 1,214 fighters. Remember, you read the bout, it doesn't include non-citizens that are not U.S. residents who fought overseas. You have to fight in the U.S. So if you're a non-citizen, non-resident,
If you're on those Singapore cards or
when you're looking at like particular bouts.
Yeah. So, but there's a lot of fighters, that fought overseas. Not a lot, but there's probably maybe, I guess you take off 100, maybe 200 fighters from that who fought on international cards and never fought in the U.S. and are probably not U.S. citizens or residents.
And that part makes no sense either. Like somehow they're not damaged.
Well, I guess it sounds like that's an American legal issue.
Yeah, I think it is an American
annoying
issue, but I do agree with you, Paul.
It's annoying.
Yeah. A third of
it's unfair. Yeah, I mean, some of them are probably big name fighters that didn't fight. I mean, I'm sure certain guys were big in certain countries and they fought repeatedly over there in their home country.
Yeah, just for visa issues or whatever, for immigration issues, it's easier just for them to fill in on the UFC Fight Night cards wherever they.
So
maybe
well, you guys are throwing it out as a legal issue. I also think of it as the two sides, right? The plaintiffs always have an incentive to make these markets as small as possible, so whoever they're suing is sort of a bigger percentage than that. And the UFC is the one saying, "Hey, it's global, it's everything," right? So it's also a byproduct of what happens when someone gets sued, right? You have to argue that the relevant market is small. And so you lead to all these things that, it's US only. Yeah, it's this, that. And now at the end of the day, once the money's out there, certain people might not get paid because of that, right? That's the way I think of it.
No, but that's been there from the beginning. That's part of the bout. That's been there for years. That's the part of the bout class description.
Right. So, right. Yeah. But it's because of what plaintiffs have to do to try to make their case. They always want those relevant markets as small as possible.
I don't know. I don't know the reason they had to do that, but it sucks for the fighters. But I guess it's just like how fighters don't care about each other. Often they're individual. I'm sure every fighter's like, let's keep eliminating more and more people out of the class. Still,
more for me.
It's the same, but it's more for me.
And I want to see if the manager for Izzy is listening to any of this and being like, maybe we can get him some money. Let's see.
They won't challenge UFC. I mean, we saw it from this. That's the funny thing. What's funny is how many fighters were angry about this this outcome. And I'm like, I don't remember ever seeing or hearing you be vocal public about this case ever.
No, I hear you. You guys keep saying challenge the UFC. I think it's challenging whoever decides the distribution of the settlement. But I don't know. I'm not a lawyer.
No, but I mean, I guess you could, but then it's kind of unfair to the other fighters because the settlement was based on who was an available class member.
The court already had decided who was going to be the class administrator. I mean, the attorneys.
Right. Yeah. I don't know. But Izzy's like, I'm in the Johnson class. Give me my money.
Sure.
So
just saying.
A third of 335 million is about 100 million. 25% of, if you think of 25%, 25% of 335 million is 83 million. So you would think that's your attorney's fees right there in between that amount. Even if you thought 20% of 335 million, it's about $75 million still that they clear.
Yeah, they're getting paid.
Plaintiffs' attorneys. I mean, 9 years. Still, that's a pretty good.
Well, it's all going to be. I think they're using the lodestar method, so they got to rack up all their hours, and the judge has got to prove it. Then he adds a multiplier.
Yeah.
So I mean, it
depends. What's a reasonable attorney's fees? Could let me know so I can raise my rates too.
Yeah, I'm sure. I think it's like $250 an hour for the attorneys.
No.
That's it.
No, we're talking about every general freaking low level clerk there.
Blended rate. Are you talking blended rate?
Oh no. Oh yeah, that sucks. So maybe bump it down to like 70 million then. Still a good payday. But
yeah, my estimate, the guy I was talking to people, 50 to 100 million the top end if everything went bad, because the UFC really buried them in paperwork. I'd say, but let's say 50 million minimums. Let's say 70 midpoint, 70 million is their total bill. So then the judge decides how good a job he did in the case, and then he multiplies it. And there's a max they can do, I guess, based on, how the damages are. So
And that's not even the costs we were talking about earlier. So goodness.
1.213 or something. I don't know. Yeah, it'll probably end up being I don't know, anywhere from 20 to 30%. You know, I can't even take a guess what it's going to be, but it'll be in there.
Oh, oof.
So a sizable amount.
I just ballparked it at a third.
That's good.
We'll see the exact number.
Third is what
Everybody will pleasantly surprised if it's more less.
Yeah. Yeah, everyone except for the plaintiffs.
The attorney, yeah, they'll be like,
wait a second. But yeah, it's a huge undertaking for those firms, and is a reason why they make the big bucks.
So lesson learned. Well, I guess I was gonna say never sue the UFC, but they got something. They won. They actually, I'm sure they made back what they put into it, even though it sucked for 9 years, almost 10 years. Compared to everybody else that fought the UFC, they got something out of it, but not the game changer they wanted. So maybe the lesson is just don't expect quick results when you challenge the UFC.
Yeah,
not the game changer, more than I expected. Hey, here's how I'll leave it. This is the final thing I guess I'll say. What I honestly think the $335 million is the price for those texts and emails, right? You talk because again, I don't need to repeat that. I don't think they had the economics on their side, but they clearly had the optics on their side. And when you guys were talking about sort of mock juries, who knows if what was driving things. And you know, we had talked a long time ago. I remember telling John a long time ago, yeah, those are just things like that are just hot docs. They don't make or break a case. But now for this case, I think the price of some of those things that were said behind the scenes is a good chunk of this $335 million. That's the way I'm leaving this case, thinking about this case. There's a cost to pay. There is no free speech.
No, there is
free speech. Isn't free.
Do not write it down in text or email.
Yeah, that too.
That's right. That's right.
Sneezed on me. Someone came in to get their last word. They're like, "Thank God."
It's the kitty nap.
Yeah, Isla. She owns the place. Look at that.
All
Isla.
right.
We're done. You never have to talk about this case again.
No, until the settlement it comes out, and then we had to talk about it then.
Yeah.
Until one or PFL goes out of business and sues the UFC, and then it's on again.
No. It'll be.
I think I'm not gonna. Their investors might sue them before they sue the UFC. Right, like, where's my money that we?
All right, guys.
Okay.
Do you have anything else?
Nope. This has been a long. I can't believe we talked this much about one thing today. One subject took this long.
Hey, after 9.5 years, it's worth spending whatever it was, an hour and a half on it.
Oh.
All right, everyone. Thanks for hanging in there with us. On behalf of John Nash and Jason Cruz, I'm Paul Gift, reminding you to keep doing business as usual.